Good morning, guys. I woke up to an absolute avalanche of stuff being put on the docket, so I've got to pass my way through it. Because there's a few smaller letters as well that I want to go through, like interesting. So I think how I'm going to do it is I'm starting here with the opposition to the motion for judgment on the pleadings. Because I want to know how Lively is going to respond to that, I think, more than anything. I will do probably a shorter video then for the small letter motions and responses, and then I think I will do another video separately for the response to summary judgment. Yeah, I think that's the best way to do it. I have to put things in little kind of their own sections, otherwise I'm like, I can't, it's cluttered. Sorry, okay, so let's have a look at this. I haven't read it. It's quite early here in the UK actually, so I haven't been up that long. But it's 35 pages. I mean, 10 of those pages are indexes and case logs. So let's start here. The introduction, which is probably going to be the same crap that she always starts with. Defendant's motion for judgment on the pleadings should be denied because it is an ill-conceived, ill-timed, and legally baseless effort to deny Blake Lively her day in court. Okay. We're hitting the ground running, I see. First, defendant's argument against the extraterritorial application of California laws cannot be squared with the unambiguous choice of law provision in the ACTA loan-out agreement, which applies to all disputes between the parties as if the contract had been performed entirely in California. The two and only two cases defendants cite in support of ignoring their own choice of law provision involve much narrower provisions, and in any event are irreconcilable with well-established California precedent. Moreover, defendants should be stopped from advancing this argument because they have repeatedly argued for the application of California law in this litigation and have responded to 3 different pleadings without challenging it, only to raise extraterritoriality once their own claims had been dismissed on other grounds. Okay. Finally, even setting aside the choice of law provision, there is a plethora of evidence of California ties to every aspect of the conduct giving rise to the California claims, as set forth here and in evidence. Ms. Lively submits in support of her opposition to the motion for summary judgment filed concurrently and incorporated by reference herein. Second, although defendant's exhaustion argument is waived, Ms. Lively fully exhausted her administrative remedies against each of the defendants. I just want to say she's also fully exhausted many of us content creators. Including It Ends With Us movie, which she clearly alleged in the second amended complaint, and is further evidenced in the motion for summary judgment. Defendants object to Ms. Lively's filing of an amended CRD complaint against It Ends With Us movie before she filed the instant lawsuit. But the law is clear that the amendment exhausted her administrative remedy in full. So, hopefully, further on, they do talk about when exactly did she file this amended CRD complaint, which incorporated It Ends With Us movie. Because we haven't heard anything. We've only had one reference to it, and it's very vague on as to When did that happen? Okay. Third, as for the retaliation claims under PIHA and Title VII, Ms. Lively more than adequately pled an adverse employment action and a causal link. Defendants made the same argument in their motion for summary judgment. However, and given the substantial record on retaliation that has been developed in discovery, I look forward to seeing this. Ms. Lively's arguments on retaliation are set forth in her opposition to the motion for summary judgment and incorporated by reference herein. Fourth, defendants' arguments against the defamation and false light claims, which defendants also moved against in their motion for summary judgment, are without merit. The requisite statements are not opinion, and neither the litigation nor fair report privilege apply. And finally, the conspiracy claim pleads all elements of conspiracy, as set forth in the second amended complaint, and additional facts supporting conspiracy are included in Ms. Lively's opposition to the motion for summary judgment, which are incorporated by reference herein. For all the foregoing reasons, the motion for judgment on the pleadings should be denied in its entirety. Okay, so we have now the background. On December 20th, 2024, Ms. Lively filed a complaint with the California Civil Rights Department. That complaint asserted 10 claims under California law, including sexual harassment, retaliation, failure to prevent harassment and retaliation, aiding and abetting the same, as well as others. That same day, the CRD issued an immediate right to sue letter pursuant to Government Code Section 12965B and closed Ms. Lively's administrative complaint. Ten days later, on December 30th, 2024, Ms. Lively timely filed an amended complaint with the CRD. Okay, so it was only 10 days later, right? Adding It Ends With Us movie as a respondent. Okay. The CRD issued a notice of amended complaint, which, pursuant to California Code regulations, stated the amended complaint is deemed to have the same filing date of the original complaint. The original notice of case closure and right to sue issued in this case remains the only such notice provided by the CRD. Ms. Lively thereafter received corresponding right to sue notices from the EEOC as to both Wayfarer and It Ends With Us movies. As a footnote, Ms. Lively served the Wayfarer parties with both her initial and amended CRD complaints and the right to sue notices. Indeed, the Wayfarer parties admit they received such service. Okay. My comment on that is Wayfarer kind of did frame that differently in their initial motion for judgment on the pleadings. So kind of neglected to mention that they had received the amended right to sue letter. On December 31st, 2024, Ms. Lively commenced this action. That same day, defendants and others filed a complaint in Los Angeles Superior Court asserting California claims against the New York Times based on their reporting about Ms. Lively's CRD complaint. On January 16th, defendants filed a retaliatory lawsuit against Ms. Lively in this court asserting defamation and related claims under California law. 2 weeks later, they filed an amended complaint, again asserting claims against Ms. Lively under California law. Ms. Lively moved to dismiss on the grounds that, among other things, the first amended complaint was based on statements protected under California law by the fair report privilege, the litigation privilege, and Section 47.1. Defendants agreed that California law applies to their claims. Okay. Argument. 1. The court should conform the second amended complaint to the evidence. As detailed further below, defendants' attacks on the legal sufficiency of the pleadings are meritless. But they are also pointless, because even if defendants had identified any deficiency in the second amended complaint's allegations, the court should conform the pleadings to the evidence in the summary judgment record and evaluate defendants' arguments on that basis, measured against the evidence in the summary judgment record. Defendants' arguments all failed. Okay. There's a footnote here. I think I've gone past the point it applies, but I'll read it anyway. Because the second amended complaint alleges that Ms. Lively filed an administrative complaint with the CRD and obtained right to sue notices, those documents are both referenced in and integral to the pleading and therefore properly considered by the court on a Rule 12C motion. Okay. Federal Rule of Civil Procedure 15b2 permits amendment of the pleadings at any time and to conform them to the evidence. That rule applies at the summary judgment stage, even to consider claims not expressly raised by the complaint. In considering a request to conform the pleadings, the key inquiry is whether allowing the amendment would prejudice the opposing party, and specifically whether allowing a party to conform will have disadvantaged its opponent in presenting its case. Here, conforming the pleadings to summary judgment evidence does not require consideration of any new claim or new theory, only facts that were unavailable to Miss Lively without discovery. We've got a footnote. Even if any of the evidence Miss Lively seeks to rely on could be characterized as supporting a new claim, such a claim would still arise from a similar nucleus of operative facts and similar legal theories as the claims alleged, and would nevertheless satisfy the test for a conforming amendment. Defendants may prefer not to deal with these facts, but they cannot claim any cognizable prejudice from the court resolving this motion on the full summary judgment record. Defendants have long been on notice of Miss Lively's claims, and the evidence that Miss Lively now seeks to rely on emerged from discovery on those very claims. At this stage of proceedings, after substantial pre-trial discovery has taken place, ignoring the entire panoply of facts developed during discovery makes little sense. The court should begin by conforming the pleadings to the evidence in the summary judgment record and proceed to consider the motion for judgment on the pleadings on that record. And there's another footnote. The court should also consider Miss Lively's summary judgment evidence in connection with this motion, because defendants have incorporated each of the instant motion's arguments into their motion for summary judgment, and have relied on significant material outside of the pleadings to support them in that motion. In doing so, defendants have effectively conceded that these arguments must be considered on the full record, and conversion of this motion to one for summary judgment would be appropriate under Rule 12D. Okay. Ms. Lively exhausted her administrative remedies as to all defendants. Defendants assert that the second amended complaint's Title VII and FEHA claims are insufficiently pleaded based on a failure to exhaust administrative remedies. That argument is meritless. Failure to exhaust is an affirmative defense that a defendant must plead and prove. Despite answering Miss Lively's original, first amended, and second amended complaints, only Miss Abel ever asserted the defense, and even then only in response to the second amended complaint. Even It Ends With Us movie, which has raised an exhaustion argument particular to itself, did not assert the defense in its answer. In other words, defendants have moved for judgment on the pleadings based on an affirmative defense they have not pleaded. And having litigated this case for nearly a year without raising exhaustion, defendants cannot invoke it as a technical escape hatch. The failure to assert this affirmative defense waives their ability to invoke it. If anyone is entitled to judgment on the pleadings as to a putative exhaustion defense, it is Miss Lively, not defendants. Well, you haven't filed it. Okay. In any event, Miss Lively more than satisfied her administrative remedies under both FEHA and Title VII. Under FEHA, the employee must exhaust the administrative remedy provided by the statute by filing a complaint with the CRD and must obtain from the CRD a notice of right to sue in order to be entitled to file a civil action. Miss Lively's CRD complaint named Wayfarer, Baldoni, Heath, Sourwitz, Nathan Tagg, Abel, and her company RWA Communications, Jed Wallace and Street Relations on December 20th, 2024, and was deemed simultaneously filed with the EEOC under the Agents Work Sharing Agreement. Miss Lively thereafter received an immediate right to sue notice and commenced this action. When Miss Lively amended her CRD complaint on December 30th, 2024, to especially identify It Ends With Us movie as a respondent, her original right to sue notice remained ineffective pursuant to California Code of Regulations, Section 10022F. The original right to sue, therefore, related forward to Miss Lively's amended CRD complaint. Right, footnote. Defendant's description of FEHA's exhaustion requirement as a jurisdictional prerequisite is misleading because FEHA exhaustion does not implicate a court's subject matter jurisdiction and can be forfeited through a party's failure to raise it. And even if Miss Lively had only exhausted her remedies after filing her federal complaint, it is well established in this district that such post-filing exhaustion is sufficient. Footnote. Miss Lively obtained right to sue notices from the EEOC on January 21st, 2025. Okay. So now we know when she did get a right to sue from the EEOC, and it was in January. So a month after the CRD. There was a lot of speculation because we haven't kind of uncovered this fact. So there's a lot of speculation circulating that she hasn't got any EEOC right to sue letter. She needed to get one, so therefore her claims are invalid. Now I pushed back at the time and said no, that's not right. Because there was a very various reasons for that, but because she was suing individuals, not just companies, she needed to get a CRD complaint letter. Whereas the EEOC only deal with the businesses, the organizations. Yes, there is the whole state federal thing as well, but on the basis that if she had gone to the EEOC, she wouldn't have been able to sue the individuals, Jamie Heath, Steve Sarrett, Justin Baldoni, etc. So she had to go to the CRD, and that she had a choice in that sense. But also, I was very much of the opinion of this case would not still be sitting in a federal court if a step had been missed, or there was something that prohibited it from being there. So clearly everything was all lined up. Now we know, we have confirmation that actually she obtained the right to sue notice from the EEOC on January 21st, 2025. Okay. Defendant's extraterritoriality arguments fail. It's too early in the morning to say that word. The California choice of law provision in the ALA expressly applies, and defendants are stopped from arguing otherwise. The ALA is the Acta Lona Agreement. Defendants contend the court cannot apply California's Fair Employment and Housing Act or Civil Labor Code 1102.5 or Civil Code 51.9, because doing so would amount to an impermissible extraterritorial application. This argument misses the mark. The fundamental issue before the court is not the territorial reach of the California statutes, but the parties' contractual choice of law. And on that point, the parties' intent could not be clearer. The parties expressly agreed that California's substantive law would govern all disputes arising out of or relating to Miss Lively's services under the Acta Lona Agreement. While the ALA is by and between It Ends With Us movie and Miss Lively's loan-out entity, Wayfarer, Mr. Baldoni, Mr. Heath, and Mr. Sarrett are similarly bound by its choice of law provision as closely related individuals and entities, as are Tag, Nathan, and Abel. A non-party is closely related to a dispute if its interests are completely derivative of and directly related to, if not predicated upon, the signatory party's interests or conduct. Right. Although often discussed in the context of forum selection clauses, the same analysis has been directly applied to choice of law provisions. In particular, Section 15.1 of the Standard Terms and Conditions attached as Exhibit A to the ALA provides that the internal substantive laws of the state of California, applicable to contracts made and performed entirely in California, shall govern the agreement's validity, interpretation, performance, and all other causes of action, whether sounding in contract or in tort, arising out of or relating to this agreement, or otherwise relating to the picture. A choice of law provision expressly stating that controversies arising out of or relating to the contract is sufficiently broad to include tort claims related to the contract. We have a footnote. Although the ALA's choice of law provision requires that the ALA be construed according to California law, New York law governs the scope of the choice of law provision itself. Okay. Here, the relevant language includes not only those words, but an express statement that California law will apply to causes of action sounding in tort, language that extends to both common law and statutory claims. Moreover, the arising out of or relating to language is broad enough to encompass statutory claims as well. Despite acknowledging the ALA's California Choice of Law clause, defendants attempt to sidestep it by invoking a general presumption against the extraterritorial application of California statutes. Their argument rests entirely on two non-binding federal district court decisions, which suggest that a California choice of law provision incorporates California's implied territorial limits by default. Okay, we have a no, don't have a footnote that I'm going to read. These cases are unpersuasive for several reasons. First, the choice of law provision at issue here is not one that presumably incorporates all of California law, including California's presumption against extraterritorial application of its law. Because the choice of law provision expressly selects California law that applies to contracts made and performed entirely in California, mooting any question of how the law would apply to a wholly extraterritorial transaction. This choice of law provision instead expresses the parties' intent to exclude the incorporation of California law's presumption against extraterritoriality. Second, and in any event, the California Courts of Appeal has never instructed that a choice of law clause implicitly imports a presumption against extraterritorial application. Rather, California appellate courts have found that extraterritoriality concerns are irrelevant once parties have contractually agreed to be bound by a state's substantive law. O'Connor and Wilson relied on a misapplication of the Ninth Circuit's decision in Gravquick AS against Trimble. In Gravquick, the Ninth Circuit held, consistent with California law, that honoring a choice of law does not give extraterritorial application to a statute, even if the contract was performed entirely outside of California, so long as the contract itself was properly governed by California law. The Ninth Circuit further explained that where a statute contains no express geographical limitations as to its application, courts may apply it to a contract governed by that state's law. O'Connor turned Gravquick's holding on its head, finding that the Ninth Circuit's specific carve-out for statutes with express geographic limitations also encompass statutes subject only to implicit geographic limitations based on the general presumption against extraterritorial application. I'm not going to go through all of this, but basically it's technical. It is arguing case law. Okay. Beyond the ALA itself, defendants' litigation conduct further confirms their shared intent for California law to govern. In their retaliatory counter-lawsuit, defendants also invoke California law, asserting California constitutional claims against Ms. Lively and other New York residents based on an article published in New York by the New York Times, and even purporting to assert such claims on behalf of an Illinois resident. They did so because they understood that California law governed the parties' relationship regardless of where the underlying conduct or the parties resided. Consistent with that understanding, defendants expressly relied on California law to oppose Ms. Lively's motion to dismiss, and discovery in this case has proceeded on the same premise. Having conceded that California law governs the parties' dispute, defendants cannot now disavow that same choice merely because their counterclaims were dismissed. I mean, Wayfarer asserted California law to their claims against Lively. Her claims are different. She is bringing different claims for different reasons. There are different parties involved. So it's not, see, in the UK, right, we were just, you're bound by England and Wales, and that's that. It's quite easy there. The law is the law, and it applies to everyone equally. And obviously in the States, you've got federal and state. Each state has its own laws. And you can, in a lawsuit, it's in a federal lawsuit in particular, each defendant can, Wayfarer have multiple defendants. In theory, the defendants could, or even the plaintiffs could argue different state laws apply to them for different reasons. So Blake Lively is saying California law here applies with Wayfarer, etc., etc. But when she was arguing in her second amended complaint, if you remember, against Jed Wallace being dismissed again, she was arguing New York law. No, he's tied to New York. She was desperately trying to tie him to New York. And then she's now saying, well, yeah, New York has jurisdiction over Jed Wallace, but California law applies. And that can get a bit confusing. Like I see why it works that way, but the system could be simplified a little. But I get what she's saying here, but also she argued for New York and in Texas in the Jed Wallace lawsuit against her in Texas, which has now been dismissed. She is arguing New York applies there too. Okay. That's good. Miss Lively's hostile work environment and retaliation claims do not implicate extraterritoriality concerns because they have a sufficient nexus to California. Even setting aside the party's choice of law provision, this case does not involve an extraterritorial application of the California statutes. California's presumption against extraterritoriality applies only when the liability-forming conduct occurs entirely outside of California. Well, I'm sure she's going to explain why it didn't occur entirely outside of California, but I mean, I would have thought it did occur entirely outside of California. I mean, some of these cases are, consistent with these principles, court routinely apply FIHA where tortious conduct at issue occurred partially in the state of California and partially or mostly outside of the state of California. One of these cases here, where is it here? Doe v. Maxim Inc. FIHA, it was decided that FIHA applied to sexual assault that occurred in St. Lucia, where a plaintiff alleged a clear nexus between the California-based conduct and the discriminatory conduct outside of California. So she is citing cases to say, look, yeah, the tort itself happened elsewhere, but California law still applied because of the nexus, and sort of arguing, well, that judgment should apply here. Okay. Defendants' contention that the second amended complaint includes no specific averments of California involvement in the allegedly hostile work environment falls flat. We have a footnote. Notably, defendants' motion focuses exclusively on the second amended complaint's allegedly hostile work environment and harassing conduct allegations, ignoring Ms. Lively's detailed retaliation and failure to prevent allegations. As discussed below, all of Ms. Lively's claims rest on a substantial California nexus. Ms. Lively also alleged and has now developed through discovery facts showing that key decisions that enabled, escalated, and perpetuated the hostile work environment were made in California by executives supervising Ms. Lively's employment from Wayfarer's California headquarters. Okay, and then the footnote just references the fact that Wayfarer and Baldoni and Heath live in California. For example, the record shows that Mr. Baldoni, the film's director and Wayfarer's chairman, and Mr. Heath, Wayfarer's CEO, made critical pre-production decisions from California that enabled harassment to occur and left cast and crew without protections once filming moved to New Jersey. Indeed, in March 2023, a female producer warned Mr. Heath that Mr. Baldoni's dual role as both the film's director and Wayfarer's chairman created an obvious conflict of interest and urged the company to engage a separate HR presence for the production. I thought they did, though, because there was like a hotline which on the call sheets which people could call to raise concerns, and it went to a third-party company. That's in the motion for summary judgment, and I think there's call sheets in evidence as well which show that phone number. Kasaritz didn't know where it went in his deposition, but it wasn't an internal thing to Wayfarer. It was an external third-party company. So they did engage a separate HR, if you like, presence. Mr. Heath, acting from California, decided not to follow advice. No, I don't agree with that. I don't agree with what she's saying here. It may not, I can't remember, because I'm trying to recall this without it in front of me. It may not have been specifically a HR, but it was a phone number that people could call to raise concerns, including harassment, sexual harassment. They could raise their concerns, and it would go to like an external company. I'm pretty sure it was a law firm. But they could raise those concerns, and it was on the call sheets which were handed out to all the cast and crew. So I don't agree with her saying that Heath ignored that advice. At the same time, Wayfarer declined to provide sexual harassment training to cast and crew after a California-based entity informed Wayfarer that Redacted would not be responsible for the training. Another decision made in California from where Wayfarer operates. But there was various training and things like that. I think this is being framed as Wayfarer did not do what the training that I wanted them to do, but that's not the same as Wayfarer doing no training at all. They both attended the training provided by a third party within days or a couple of weeks of filming, and they had various kind of respect in the workplace trainings throughout. When someone has to kind of not be honest in these things. I don't like it. These omissions guaranteed that once filming began, there would be no meaningful mechanism for Miss Lively or any other cast member to report inappropriate behaviour. For fuck's sake. Right, she could have contacted SAG-AFTRA. She could have gone to Wayfarer's HR. She did not. In fact, she specifically said, if I blackmail you with this letter, I'm willing to forego a more formal HR process. Sign it and we'll forego a more formal HR process. Just by saying that, she is acknowledging there is a HR process. Ugh. God, I'm annoyed already. There were a half a dozen ways that Lively could have reported inappropriate behaviour. If she had reported to SAG-AFTRA, they would have shut down the entire set and investigated. The resulting on-set misconduct was the predictable manifestation of those California-based management decisions. Other decisions in California set the tone for harassment. Shortly after Miss Lively accepted the role of Lily Bloom, Mr. Heath remarked that Miss Lively would be birthed into the role. Oh, fucking hell. A statement that sexualized her. And invoked female reproductive imagery to describe her professional contributions. I, as a female, do not see any issue with that terminology. It just means that she would be kind of, I don't know, don't even have to explain it. It's quite self-explanatory, but she is just taking this completely out of context. This objectification, which it's not, made from California, where Mr. Heath resided, signalled that Miss Lively's value was tied to her gender rather than her talent. Well, you've got no fucking talent, so it's got to be tied to something. But no, it's not tied to gender either. This is just bloody stupid. During a pre-production Zoom meeting with producers, Mr. Baldoni, joining from California, lashed and later sent an apology from California, acknowledging that he had mansplained and had been dismissive. I mean, that is not harassment. Later, when Mr. Sachs attempted to push back against Mr. Baldoni during filming, he reacted with explosive anger, slamming his hands onto the back of a chair while angrily yelling the producer's name. So what are we saying here then? Justin Baldoni's not allowed to get angry? How is this related to gender or sexualization? The absence of reporting structures left Miss Lively, Miss Sachs, and other casting crew vulnerable to harassment. Right, okay, now we're starting to see where Alex Sachs was brought into all of this. Because she was friendly with Justin Baldoni throughout the entire filming and production. It was only when she went to Book, I don't know if it was Book Bonanza she went to, but when she did something post-production, and she had a conversation with someone. At that point, Alex Sachs then stopped speaking to Wayfarer. But that was way after before production. That was way after filming even. So Miss Sachs explained that the only people who had authority to take corrective action were Mr. Baldoni and Mr. Heath. an obvious conflict of interest and one that she had raised months earlier, which Wayfarer's California leadership ignored when it decided not to engage separate HR. When Redacted and Ms. Lively complained to Redacted, so that would be Jenny Slate, and I'm guessing that complaint was to Sony or Ange Giannetti, who works for Sony, who was also located in California, about Mr. Baldoni and Mr. Heath's inappropriate behaviour. Redacted took no corrective steps because Redacted's role was limited to Redacted, a position Redacted had communicated to Wayfarer months earlier when it disclaimed responsibility for harassment training. What are we saying here then? Blake Lively got everything she wanted, a letter for her PGA mark, her more time, like a lot of time in the editing suite during the director's legally protected period. She got all the weighing over the songs, staffing, wardrobe, the script, the marketing. She was able to take control over all of that, but she could not get Wayfarer for love nor money to implement a separate HR system and harassment training. Like that her powers were limited to taking over the entire film, but this little side bit, she just couldn't conquer it. She could not get them to do anything. I call bullshit. Right. These facts show that the harassment on set was the foreseeable extension of a hostile environment conceived in California, directed by California executives, and perpetuated through California-based decisions, policies, and emissions. No, I don't believe the harassment on set was foreseeable. I think it was foreseeable to you because you planned it. Moreover, defendants overlooked that Ms. Lively alleges that the harassment did not end when on-location filming concluded. I just want to remind everyone, by the way, very quickly, Blake Lively, even if she felt harassed, she sure as hell took advantage of it, right? That's something that most women who really are sexually harassed in the workplace do not get to do. Most women either carry on in fear of losing their job or do lose their job or are demoted and demeaned in some way. Lively did not experience a single part of that, right? Lively seemed to, as Wayfarer put it, seemed to actually benefit from her harassment, right? Alex Sachs is also no stranger to doing that. Because when she was working with Andrew Duncan on the Florida project, and he was accused of sexual harassment, after ignoring it for a long, long time, she eventually decided that she was just going to take ownership of the production studios that he owned or co-owned. Benefited from it. So when it comes to sexual harassment allegations and what can I get out of it, these two are peas in a pod. Sometimes reading these filings is like therapy. Moreover, defendants overlooked that Ms. Lively alleges that the harassment did not end when on-location filming concluded. As the second amended complaint makes clear, defendants continued to engage in harassing and retaliatory conduct long after production wrapped, including a smear campaign planned, coordinated, and implemented from California. Under California law, retaliatory acts can constitute continuing harassment of an employee. Ms. Lively's retaliation allegations confirm a direct California nexus. Ms. Lively alleges that in August 2024, Wayfarer's management retained California residence tag, and Miss Nathan, they are now California residents, because in her second amended complaint, Melissa Nathan was a New York resident. To get ahead of Miss Lively's grievances by planting false narratives portraying her as a bully and a mean girl. And Mr. Wallace declared under oath that he understood the impact of the work that he and Street Relations work for Wayfarer to be in California, and he thought they were doing business and providing services to individuals in California. Gearing up to hiring crisis PR and legal representation to implement the retaliation campaign in June 2024, Mr. Heath from California directed the preparation of a timeline of the alleged incidents involving Miss Lively, which includes a host of additional California conduct. Okay, so Heath wrote a timeline in California, so therefore this lawsuit, California law applies. In addition, after Miss Lively filed her CRD complaint in December 2024, another California-based act, defendants launched a second wave of retaliation executed in part through their California-based attorney Brian Friedman, who made defamatory public statements and filed defendants' retaliatory counter lawsuit from California. I mean, they weren't defamatory, they were true, in my opinion. Each of these harassing and retaliatory acts, planned, directed, and executed from California, constitutes conduct subject to the California statutes. I'm not going to go through all that. I will look at this footnote though. Wayfarer Party's reliance on Garcia against ROC Nation is also misplaced. In Garcia, the plaintiff's only alleged California-related conduct was accompanying the defendant to strip clubs, and the claim failed, not for lack of California nexus, but because the plaintiff did not allege he was singled out based on sexual orientation. By contrast, Miss Lively expressly and specifically alleges harassment and based on her sex, making Garcia inapplicable. Okay, so that's just opposing a case citation that Wayfarer put forward. Okay. These cases, each involving little to no California-based conduct, stand in stark contrast to the facts of this case, where, among other things, the hostile environment created by defendants specifically originated with decisions made in California. Complaints of harassment were reported and addressed in California, and the subsequent campaign of harassment and retaliation against Miss Lively was orchestrated from California. Wayfarer is liable for harassment and retaliation as a joint employer. Wayfarer's attempt to shield itself from liability for harassment and retaliation on the grounds that it was not party to the ALA fails. Both FEHA and Title VII extend beyond the directly employing entity, whereas here there are joint employers, i.e. more than one entity that share or exercise significant control over an employee's work. In determining joint employer status, California and federal courts consider the totality of circumstances that reflect upon the nature of the work relationship of the parties, with emphasis upon the extent to which the defendant controls the plaintiff's performance of employment duties. Relevant factors include payment of salary or other employment benefits, the authority of the defendant to hire, transfer, promote, discipline, or discharge the employee, the authority to establish work schedules and assignments, and whether the work is part of the dependent's regular business operations, among other factors. And Wayfarer went through all of this, like, well, how much control did we have over Lively's terms of her employment? And they whittled it down to none, pretty much. She decided her hours. She even decided who could be the director. She had to approve Baldoni as a director. She had to approve his body double and stunt double. His body double and stunt double. They provided the use of like private jets. She could approve the jet and the pilot. For her hotels, she could approve the hotel and the suite. For her family's use as well, not just hers. She approved her hours. She approved the car that was made available to her to transport her from her home 15 minutes away. Because they moved the entire filming set from where it was supposed to be in, was it Boston, I think? That was where it was planned, to New Jersey to accommodate Blake Lively at her request. They moved the schedule around, the filming schedule, at her request. So they did not have any kind of real control over her. And when I say control over her, I mean as an employer does with an employee. Here the facts demonstrate that Wayfarer and It Ends With Us were Miss Lively's joint employers under Title VII and FEHA. While It Ends With Us movie is a party to the ALA, the evidence shows that Wayfarer exercised and retained exclusive control over Miss Lively's work. No, it didn't. And working conditions. No, it didn't. In connection with the film. It Ends With Us movie was simply a single-purpose vehicle formed to produce the film, while Wayfarer financed the project, approved key creative and personnel decisions, and exercised control over cast and crew, except for Lively. For example, Wayfarer executives, including Mr. Baldoni and Mr. Heath, approved all casting decisions. And Mr. Baldoni admitted his authority to hire, fire, and discipline all cast and crew as he sees fit. Wayfarer acquiesced in and accepted Mr. Baldoni's assumption of the director role. She really seems to have a bug up her ass over the fact that Baldoni was the lead male, but also the director and the owner, co-owner of the co-founder of the of Wayfarer, the production studio. She really seems rattled by that. I mean, it was okay when her husband did the same thing. Or something similar. Was an actor, was a producer. His marketing company that he co-owned did all the marketing for Deadpool, etc., etc. But Justin Baldoni, no, it's too much. And I think that's her tell. I think she knows it's too much power because she has seen her husband do the same thing. Wayfarer also permitted Mr. Baldoni and Mr. Heath to exercise supervisory authority on its behalf throughout the production of the film. Indeed, testimony from various cast and crew members shows that Wayfarer was seen as their employer, carried out through the actions of Mr. Heath and Mr. Baldoni. Wayfarer also directed the schedule, location, and conditions under which Miss Lively performed her work. Are you actually kidding? I'm not going to repeat myself. I've just covered all the reasons why they really did not. Wayfarer also made all human resources related decisions for the film. So they do have HR. Wayfarer reviewed whether harassment prevention training would be provided under California law and ultimately decided to conduct this training for all cast and like a couple of pages ago, didn't she say that they declined to provide anti-harassment training? But now she's saying that they reviewed whether harassment prevention training would be provided under California law and ultimately decided to conduct this training for all cast and crew. I need to go back. Oh yeah, here we go. At the same time, Wayfarer declined to provide sexual harassment training to cast and crew. What? Okay, and then here she says ultimately decided to conduct this training for all casting crew. So they did. I can't even keep up with this. No, I can, but so a few pages ago she said that they did not provide anti-harassment training for casting crew. Here now she is saying yes, they did. Moreover, in its summary judgment motion, defendants cite to Wayfarer's employment policies as Wayfarer received and instigated a HR complaint related to the film. Again, I thought she said there was nowhere for her to go and complain. And Wayfarer made the decision not to investigate Miss Lively's and Redacted's concerns. Yeah, it's days like this when I'm reading stuff like this, I'm glad I don't drink. Wayfarer profited from the film's success, stood to gain from Miss Lively's performance. I don't understand what she's insinuated by that. You're a friggin' actress. They wanted you in a film. They paid for you to be in a film. And honestly, I don't think they gained from her performance because the world is currently pissed off with her performance, both during the filming and the marketing. Wayfarer profited from the film's success, stood to gain from Miss Lively's performance, and was listed on the insurance policies covering the production. Finally, Wayfarer retained Tag, Miss Nathan, Miss Abel, Mr. Wallace, and Street Relations to carry out their PR strategy against Miss Lively. Courts routinely impose joint employer liability under FEHA and Title VII, where affiliated entities exercise significant control over an employee's work environment. For example, in Medina against Equilon Enterprises, the defendant was deemed a joint employer because it exercised pervasive control over daily operations, personnel decisions, and compliance obligations. The record here overwhelmingly demonstrates that Wayfarer is liable as a joint employer with the Ends With Us movie under FEHA and Title VII. Miss Lively's defamation and false light claims must proceed to trial. In each of the motions, defendants assert that Miss Lively's defamation and false light claims are subject to the litigation privilege, the fair report privilege, and the opinion doctrine. Miss Lively responds to these arguments here, and both are incorrect, and we have a footnote. The court need not engage in a choice of law analysis as to these arguments because there is no conflict between New York and California law as to the specific arguments that defendants advance, and the defendants do not suggest otherwise. So, firstly, defendant's opinion defense is meritless. The Wayfarer defendants assert that whether conduct amounted to sexual harassment or retaliation reflects unactionable opinion. As an initial matter, this ignores that defendants asserted verifiably false facts in connection with the statement. For example, their false assertion that Lively fabricated harassment claims as part of a ploy to take over the marketing of the film, an assertion which further falsely pinned responsibility on Lively for a marketing plan that was approved by Wayfarer from the start. In any event, the argument is wrong as a matter of law because statements asserting that an individual made a false accusation or lied for financial or personal gain are capable of being proven true or false, and attributing specific and objectively verifiable motives for fabricating accusations of sexual harassment is not protected opinion. Defendants rely heavily on Coleman against Grant, but ignore that Coleman turned on the statements being clear and that the speaker's views were not based on any undisclosed facts, but rather was based entirely on disclosed facts from which the readers were free to determine whether they agreed with her characterization. Here, the defamatory statements state expressly, or at minimum imply, that defendants possess substantial undisclosed evidence proving that Lively fabricated her claims of sexual harassment and retaliation for reasons other than the truth, such as to fix her negative reputation or take control of the film. I mean, the video that they put in, the kind of behind the scenes footage, was pretty persuasive to me. Defendants' arguments that their denials of a smear campaign are not defamatory because they lack a precise definitive meaning fails for similar reasons. Contrary to defendants' characterization, the defamatory statements not only include denials of participating in a smear campaign, but also specific factual statements such as that representatives of Wayfarer did nothing proactive nor retaliated, and only responded to incoming media inquiries. Whether the Wayfarer defendants retaliated against Lively, including by proactively shaping or planting negative stories about her, is objectively verifiable and, in fact, will be verified by a jury. Nor are the defamatory statements protected as general denials, because denials coupled with accusations that the accuser will be proven a liar cross the line from general denial to specific accusations, reasonably susceptible of a defamatory meaning. The litigation and fair report privileges do not apply. The defamatory statements are unprivileged. Oh, we have a footnote. Exhibit 271 is Appendix F to one of the expert reports Ms. Lively served and identifies all of the defamatory statements. The motion states wrongly that the second amended complaint cynically fails to note the timing of the alleged defamatory statement. The second amended complaint footnotes include citations to the articles that contain the defamatory statements and reflect the dates of publication. Right? Okay. Neither California's nor New York's litigation privilege applies to attempts to litigate in the press. The defendants concede that neither California's nor New York's litigation privilege applies to the defamatory statements because Friedman made them outside of court. Instead, the Wayfarer defendants now argue that the defamatory statements are protected based on the fair report privilege, which applies to a fair and true report of any judicial proceeding. But the fair report privilege does not protect litigating in the press either. Further, An overlap between the subject matter of the report and the subject matter of a proceeding does not suffice. The ordinary viewer or reader must be able to determine from the publication itself that the publication is reporting on the proceeding. The defamatory statements are unprotected by the fair report privilege because they constitute litigating in the press and do not reflect reports of any judicial proceeding. Instead, the defamatory statements are an amalgamation of the defendant's version of the underlying events, which are not protected by fair report. Defendants concede this by admitting that the statements repeat allegations defendants had already asserted or would soon assert in this action. At the time of the December 21 statement, the only active proceeding was Lively's privately filed CRD complaint. Privately filed but publicly blasted, which the statement did not expressly reference, nor did it give readers any way to understand that it was referencing Lively's CRD complaint as opposed to the New York Times article itself. Indeed, at this time, defendants' chosen PR strategy was the preposterous assertion that Lively did not ever intend to litigate her claims, but had filed a fraudulent CRD complaint for the sole purpose of laundering a story into the New York Times. Even if readers had somehow understood Mr. Friedman to be referencing the CRD complaint, the December 21st statement is not a fair and true report of it, because it characterized it as filled with false allegations designed to fix Lively's negative reputation, which was garnered from her own remarks and actions, and that his clients did nothing proactive nor retaliated and only responded to incoming media inquiries. I mean, it is quite clear that that statement from Friedman was responding to the CRD complaint. Not so much the CRD complaint, because that never needed to be made public, but to the way the CRD complaint was handed to the New York Times and put on a world stage. By the time of the January 7th statement, the active litigation proceedings also included Lively's complaint in this matter and the California state lawsuit, which named only the New York Times as a party. The January 7th statement also does not provide any indication what proceedings it was about or a fair and accurate description of any of the ones that existed at that time. Nor can the defendants rely on the California state lawsuit as the basis for the fair report privilege because they attempted to assert nearly identical claims in the first amended complaint, which the court dismissed, and for the reasons explained in the various Rule 11 motions, were frivolous. Well, we had to get one of the sanctions motions in here somehow. I think that's now completed my bingo card. Courts do not condone the deliberate institution of baseless litigation for the purpose of fabricating a reporting privilege. For the same reason, the defendants cannot cloak the January 18th statement or the January 25th statement in a fair report because they related to the now dismissed sanctionable First amended complaint. She's talking about Wayfarer's first amended complaint. To the extent they report on any proceedings. I mean, seriously, she's saying that their first amended complaint was sanctionable, yet her second amended complaint contained posts of herself in blue jeans in her apartment, and everyone and their dog was expected to know and understand that she is a New York resident based on that. Even though she did not expressly state that she was a New York resident, if we were to use Lively's arguments here against her, she did not say she was a New York resident. She did not. She said, it says New York lady. Well, doesn't say Blake Lively. Could have been referring to anyone. And that second amended complaint absolutely should have been sanctioned because it was shit. Even if that were not the case, nothing about the content or context of the January 18th and 27th statements indicate that Mr. Friedman was describing judicial proceedings, let alone providing a fair and true report of them. Attorneys like Friedman, we've just done a Friedman blast now. Attorneys like Friedman who choose to litigate their cases in the press do so at their own risk because applying the privilege to public mudslinging would serve no purpose but to provide immunity to those who would inflict upon our system of justice the damage which litigating in the press generally causes, poisoning of jury pools and bringing disrepute upon both the judiciary and the bar. Oh, for God's sake. She does not like Friedman. Oh, we have a footnote. Well, let's, in for a penny, in for a pound. Defendants suggest that Mr. Friedman's ethical obligation to defend his clients necessitated his public statements, but offers no citation to support the assertion or attempt to reconcile such a claim with California law, holding that attorneys engaging in mudslinging, while a less physically destructive form of self-help than a public brawl, is nonetheless one of the kinds of unregulated and harmful feuding that courts and their processes exist to prevent. Excuse me, right? This woman put Taylor Swift's name into the hat, said Taylor Swift had knowledge. Justin Baldoni literally stood in an apartment that Taylor Swift was at whilst he had a dressing down from Ryan Reynolds. I think he was there another time, so it was at least twice. Justin Baldoni was there with the script changes as well. Taylor Swift was there, and he tried to subpoena Taylor Swift, and she called it abusive to the press. She has used DARVO, terms like predator and DARVO. I mean, I can't with her anymore. Right, the second amended complaint states a claim for conspiracy. Second amended complaint sufficiently pleads all the elements of civil conspiracy. Footnote, specifically the Wayfarer defendants 1. Agreed to execute a social attack plan. 2. Engage in overt acts to further the agreed upon plan. 3. Intentionally participated in furthering the agreed upon plan. And 4. Caused resulting harm. In any event, the summary judgment record puts this issue beyond doubt. Conclusion, defendant's motion for judgment on the pleadings should be denied. Yeah, so there's she contradicts herself in this. She completely misrepresents the entire lack of control Wayfarer had over her employment conditions. And I've now come to the decision that the reason she is so aggrieved that Baldoni had multiple roles and, references this as too much power is because she is looking at her own husband being largely in the same situation, being the lead actor, being a producer, and, having, roles in various companies that worked on his film, such as Maximum Effort. And probably feels it's too much power, either because she wants that power for herself, and this was her attempt to match her husband, because God forbid a man be successful here, or I don't know, I don't know, it could be that she is a bit resentful of her husband even, and all the power he seems to have on films, and she's an actress in a bikini on a deserted island surrounded by sharks. Like, she doesn't get much better than that. Who knows? But I definitely think she recognizes something and expected almost lashed out in anticipation that Justin Baldoni would be like her husband. That's my opinion. That is pure speculation. However, I'm starting to think that there's something in that because she really, really does not like and takes issue with the fact that Justin Baldoni had multiple kind of leadership roles in this film. And whilst she may be, I don't know what it's like at home to live with Ryan Reynolds. I can't even imagine it. I would need therapy forever. But I can imagine that it's not always, fun for her. If I'm being a little bit humble towards her, which I'm not happy to do that, but at the end of the day, it's disingenuous to not. So I do think that Ryan Reynolds is not an easy person to live with. And she probably sees herself like, because when they met, when they were marketing the Green Lantern, right, one of the worst films I've ever seen. She made a reference to him on this recorded interview that she had security, and he turned around, right, and he said, "You've got security? How have you got security?" And she said, "I'm a big deal." Right? I mean, egotistical, but she is saying, "Well, I'm a big deal, so I've got security." And Ryan Reynolds was almost like surprised that she's got security. Well, now Ryan Reynolds is the big player in the relationship. The dynamic has changed. I don't think she likes it, even if she loves and supports him, which I'm not entirely sure. But I don't think she likes the fact that now he is the big name, that the person who brings the money in. She is a big name largely because she's married to him. Now, is that particularly fair? Probably not. I hadn't heard of her. But when I started this case, I recognised her from Met Gala, like red carpet walks with that dress that turned inside out. But I had never seen anything she'd been in. And I do think that when it became apparent to her, and I'm not saying it was a good idea for Justin Baldoni, for Wayfarer to have all these multiple roles. They probably, I wouldn't go as far as to say there was a conflict of interest, but there is certainly the perception of conflict of interest. And I think once it's been raised that someone is concerned that it could be perceived that way, then maybe at that point, I can't disagree with the suggestion that they should have done something to separate that out. However, I also acknowledge that they did actually have a third party organization, company. I believe it was a law firm. They had a phone number on all the call sheets, which were handed to every cast and crew, where they could report on-set concerns. Well, concerns didn't even limit to on-set. They could report concerns, which included harassment, sexual harassment, etc., discrimination. So there was mechanisms in place, and I do think Lively is misrepresenting that heavily in this, and I don't like that at all. But I'm kind of just gone, a little light bulb in my head has just gone. Did Lively kind of almost anticipate a similar, Justin Baldoni was going to be a bit like Ryan Reynolds, because Ryan Reynolds holds all these big titles when he does, especially the Deadpool movies. He has these major roles. So, is that what happened here? And was she like, "Oh no, I'm not having any of it"? Maybe I don't know. It's just a thought process. Okay, dokie. I'm gonna leave this here, and I am gonna go and head off and do the motion for summary judgment and the smaller letter. motions in 2 separate videos.